Welcome, everybody. I'm glad that so many of you came. I'm very happy to welcome Corina Heri for our talk. Mr. Corina Heri, who is Associate Professor of Human Rights and Climate Litigation at the Vrije Universiteit in Brussels, and the primary investigator of the FWO-funded Temporal Law project, which just started, I suppose, this month. So very fresh. Corina is, of course, an expert in climate litigation and works particularly on human rights-based climate litigation and the role and functioning of courts in relation to all of that. And today she will be discussing human rights law's interpretive ethic as determined by a narrative of scarcity, particularly as exemplified by cases by the European Court of Human Rights. We are so happy to have her here as part of our project on climate litigation that's hosted here at ASELG. And you will have about 45 minutes to present, and then we will have another 45 minutes to discuss and have questions. Thank you so much, and the floor is yours.
Thank you so much. Can everyone hear me? I'm sorry about my voice. I'm getting over a cold, but hopefully it'll hold out, and this will be enjoyable to listen to. So thank you so much for the invitation to be here today. Thank you especially, Christina, for making. It's lovely to be back where my interest in rights-based climate litigation started, which is this building. So that's particularly nice for me. Today, what I want to talk about is a topic that brings together a few of my ongoing research interests. And that's the idea that there is a narrative of scarcity that shapes how we interpret human rights in the face of climate change. So there's different ideas and topics that are pulled together by this overarching use of narrative, and you can tell me whether it works or doesn't work at the end, but we'll see. So what I'd like to do, what I'd like to do by focusing on narrative and how it shapes human rights law, is to discuss this figure or this sector of scarcity that stands in the background as human rights law encounters climate change, often for the first time in the context of litigation. And that focus on narrative is a way for engaging critically with the law. It's a way of opening a window to different strands and ways of doing critique. We can talk about how foregrounding a narrative of scarcity allows us to engage with trail scholarship, with feminist scholarship, with post or decolonial scholarship, and so on. There's different doors that, especially in the context of the system that I work on, the European Convention on Human Rights, very often remain firmly closed. And so why narratives? I think I could have given a very similar version of this talk if instead of narratives, I talked about framings or ideologies or discourses, but I think narratives work to pull together the different things that I want to talk about and putting them into their contexts. That's because there's lots of work on legal narratology that tells us that essentially litigation is a contest of narrative. It's different narratives fighting for recognition of their understanding of the law, and climate litigation fits that idea very well. So climate litigation is an area where we're seeing different actors and participants in these cases trying to have their version of the facts, of the science, and of the law recognized through the narratives that they're presenting. And that, of course, includes the narratives that are up for the European rights. Like I said, that's the jurisdiction that my work predominantly has focused on when I'm looking at climate litigation. And I think it's one that's worth watching closely, if critically. Recently, we've seen quite a bit of scholarship emerging that's skeptical of the transformative potential that climate litigation as a whole, and especially climate litigation before the European Court of Human Rights, can have. And so after the initial excitement after the 2024 Klimasenioren judgment from this court, when of course there was a lot of attention and also a lot of celebration of the fact that the European Court of Human Rights had found a human rights violation in the face of defective regulation from the case, the state in this case being Switzerland. We've seen more scholarship since then that says, well, actually, the transformative potential of these cases and the practical implications of these cases are maybe less transformative than we thought they were. Maybe they're more modest, or maybe they're not able to achieve very much at all. Now, I have good reasons to think that that's not true. I've been working on an empirical project together with Charlotte Blattner and Arve Karvedian, two colleagues, where we've been mapping all of the official responses to this judgment, to the Klimasignorinen judgment. And we've seen that actually about a third of them have been positive. And actually, especially on the lower levels of the Swiss federal hierarchy, so on the communal and the cantonal level, have been empowered by this ruling to ask for regulation and especially more ambitious engagement with greenhouse gas mitigation. So we do see some things happening, and at the same time, there are certainly very clear issues with this court's engagement with climate change. Those issues are particularly important, I think, to discuss because, of course, this court was the very first international court to hold a state responsible for violating human rights in the context of its mitigation policy. And for that reason, this judgment has been looked at a lot and has also been cited a lot in judicial dialogue. So it stands to be influential despite its very notable limitations. And so for that reason, this talk is structured around how the European Court of Human Rights approached climate change and how that approach, how the interpretation of European human rights law was decisively shaped by a narrative of scarcity. Now, I'm going to argue that that narrative of scarcity is not unique to climate cases. It's something that shapes the way that this court engages with climate change overall. So in other words, understanding the court's response to climate change and understanding the scarcity-based response to climate change also means understanding this institution and its as a whole. And to do that, I have broken this up into 3 steps or plot points, maybe, if we're staying with the idea of narratives. So as you can tell, narratives are a way of bringing together different topics. So today, this is going to allow us to do several different things, some more granular and practical, and others a bit more theoretical. So first, what I want to do is to situate the Klimasignorinen judgment in its context, so in its legal, political, and institutional context. And that allows us to ask, how does European human rights law evolve? Can it change only in one direction, or can it also lead to a regression of standards when times are hard? And what are the underlying normative commitments of this system? In a second step, we can then start to understand the course of human rights laws, especially European human rights laws, limitations. By that I mean the very decisively economic and neoliberal thinking that's inherent in this narrative of scarcity. And I'll argue that that narrative shapes the overall interpretation of the ECHR and that it leads to very specific spatial, personal, and temporal limitations in how this court engages with human rights impacts. And that then brings me to a third step where I want to engage with the possibility of thinking beyond this model and reclaiming, if not political power, then epistemic power over how European human rights law is interpreted. So to start, I'd like to talk about the Klimasignorinen judgment for a bit of context. That means not just assessing how this judgment came to be, but also understanding how the process of interpretation works at the Strasbourg court. And if you speak to people who are working inside this system, many of them will tell you that we can't ask this court to do more under its current circumstances. So the court is seen as a vulnerable and contested institution, and pushing its interpretation any further is seen as bringing it to a potential breaking point. And I'd like to argue two things in this regard. So first, that these discussions are at their core replicating or about a narrative of scarcity, which I'll explore in a bit more detail in a second. And secondly, the interpretation of human rights law that this court carries out in its climate cases and overall can be seen part of a much larger and longer dynamic that is continuing to be reinforced over time. And to build toward these conclusions, I draw a bit more generally from the context of this institution. I have two examples here on the slide. They both come from judges or former judges of this court, and they show the concerns they have about the court's ability to manage its caseload. So the first one was made in the context of the court's response to rule of law crises. And it comes from two former judges, Shofar O'Leary and Yongo Grozev. Shofar O'Leary being the former president of the court, who was the sitting president when the court's climate judgments were decided in 2024. And they argue that the court's work inevitably entails focusing scarce resources on some cases to the possible detriment of others. How does a court with 46 judges, 60,000 plus applications, against a background of constant political firefighting and a modest budget, which had been frozen for several years, manage its caseload? The second quote on the right is from the current president of the European Court of Human Rights. It comes from last year's annual report from the court. And he takes a similar perspective. He argues the court must reconcile three priorities, which are the foundational elements of its institutional legitimacy: efficiency, visibility, and accountability. So these are the priorities that we see the court setting. We see the words scarcity, we see the words efficiency here. We don't see quality of the case law, and we don't see principled reasoning. And this, in my opinion, matters because what you see the judges describing is an institution under strain. Mentioning scarcity and efficiency and describing a court that's continually under pressure. And that's being asked to do a lot with very little. And efficiency is a word here that gets used a lot. It's become kind of a background guiding principle of how the Strasbourg court approaches its work and its role. And that's something that's happened through successive waves of reforms of the court that have happened in the last decades. And so we've seen reform processes, both through political pressure and through additional protocols to the ECHR, that have reshaped how this institution approaches the interpretation of human rights and other things. So we see a court that's dealing with scarce personnel, a huge docket, and political backlash or pressure. And that's turned the perspectives of this institution towards conserving its scarce resources and managing those resources. And this is all currently coming to a head. So in 2025, we saw a letter by states being sent to this court asking for changes to its migration case law, saying it had gone too far, interfered too much with state decision-making. And that's a process that's still currently ongoing, that's going to lead probably first to a political declaration and then maybe to a binding instrument to reform how the court approaches states' obligations. Now, that's not directly related to climate change, but at the same time it is, because there is clear evidence in empirical research, I'm thinking of Eski Yildiz here, that shows that when these kinds of tendencies surge at the court, there's a demonstrable response in the case law. The court becomes less willing to recognize new obligations, less willing to find violations with the ECHR, and it tightens admissibility criteria and adopts a more procedural and substantive approach to how it evaluates cases. So things happen in the case law when the court is under pressure. Now, many scholars who work on the ECHR will tell you that this is just how it is. The court is doing the best that it can with the scarce resources that it has. And we should limit our critique of this institution in order to isolate it from further backlash. So we should close ranks around the court and avoid additional criticism. Now, I don't agree with this approach for reasons that will become increasingly clear, I think, in the remainder of this presentation. But whether we agree or not, it shows that, or this kind of approach shows that the narrative of scarcity, whether that's scarcity of room on the docket, scarcity of legitimacy resources, scarcity of personnel, whatever that kind of scarcity is, that narrative has become so deeply entrenched in how we approach the ECHR that it's become normalized, also in the way we approach it in our research. And to some extent, of course, that can't be blamed on the court or the court alone. That's something that has been triggered and reinforced by pressure from states over years, including through the adoption of reform protocols to the ECHR. But what we don't talk about enough is that wherever it came from, this narrative of scarcity or efficiency reshapes the case law, and it does that in deeply problematic ways. Problematic not just because it risks stagnation or even retrogression in how the convention is interpreted, but also because it risks sacrificing the rights of certain groups in order to preserve the institution. That brings me to the second point I want to make, which is looking more deeply at these scarcity narratives and the specific kinds of scarcity narratives that we're seeing in the ECHR, which are, as I'll argue, neoliberal scarcity narratives. So the court's approach to climate change has a number of limitations. These have been rather well explored in the literature so far, and we'll talk about a few of them here, especially when it comes to victim status and extraterritorial jurisdiction. These limitations are deeply wrapped up with scarcity narratives. The idea here is that there's a link between neoliberal capitalism and economically driven narratives around scarcity. And that's not a new idea, that's not my idea. And there's extensive research, and you see some names here on the slide, people whose work has influenced and inspired me in thinking about it. So it's been well demonstrated in the literature. And in this sense, engaging with a narrative of scarcity is, like I said at the beginning, a way of opening a conversation between research on the ECHR and critical legal research, including TWAIL, including various other schools of critique. The underlying story, the reason why I consider this narrative of scarcity a neoliberal one, is because it's telling a story that human wants are infinite and resources are finite, and that there's a mediation that needs to happen between those two. And this limits the possibilities for redistribution. So it considers that there needs to be an accumulation of capital and technological process to mediate how those resources are distributed. And like I said, there's a number of scholars that I've drawn on in this context in my work, but in essence, this is about applying a market-based logic to how we recognize human rights violations, how we distribute the resources necessary to respect, protect, and fulfill human rights. And this is done in a way that limits space for government interference. So it prioritizes this idea of competition for scarce resources by rational market actors. That means accepting that people or places need to be sacrificed in the pursuit of overall continuing growth and progress. So that's an idea where I've been inspired by the work of Wendy Brown. She argued when economic reality requires it, individuals may legitimately be cast off from the ship. And that's something that directly characterizes not just neoliberal ethics, but also how the European Court of Human Rights has approached climate litigation. So climate litigation has been addressed in ways that limit who can bring cases, from where cases can be brought, and that is very selective about the kinds of claims that are entertained in ways that map very well onto. So what I'm trying to say here, basically, is that the discussion of narrative allows us to examine the ideological underpinnings of European law. And that's not to say that human rights law can't work to contest or is always necessarily reinforcing these kinds of narratives and these ideological underpinnings. Scarcity has an impact, however, and that impact is by framing protection of human rights as being about the competition for scarce resources. It accepts that not everyone's rights can be protected and not everyone's needs can be fulfilled. And that in turn creates hierarchies, right? So it mediates between whose human rights violations are recognizable and which ones are not. It also mediates between who is the subject of human rights protection and who is not. Where can human rights protection be granted and where it cannot be granted? European versus non-European distinction, and so on. So it creates hierarchies. It means competing for scarce resources and accepting hierarchies and also sacrifices. And when it comes to climate change, we see human rights law really struggling with this, especially European. And we see these concerns about a flood of cases, about the legitimacy of institutions if they accept cases, decision-making. And that is allowing these hierarchies to emerge and be strengthened. So one particular idea where this gets more concrete is the idea of how the victim of climate-related human rights impacts is understood. At the European Court of Human Rights, victim status is a requirement for bringing an individual application. And we've seen the European Court of Human Rights, in response to climate change, say, well, not everyone can be recognized as a victim of climate change. Victim status can't cover everyone who's at risk because potentially that would be everybody living in the Council of Europe member states, and that would be intolerable if every single person in the Council of Europe were to bring an application to Strasbourg and say, my human rights are violated because not enough is being done about climate change. And in response to that concern, to the fear of too many cases, too many victims, what the European Court did is it narrowed the victim status criteria. It created a special test for climate cases, and it raised the bar for individuals to bring these kinds of cases to Strasbourg. And it compensated that to some extent. So it allowed representative cases to be brought by associations, by NGOs, representing bigger groups of victims, less strictly defined groups of victims. But this approach to victim status is, I'd argue, deeply revealing. It goes coupled with another restriction that the court imposed, namely its refusal to accept extraterritorial climate cases. So states can only be held responsible for the impacts of their climate policies that happen on their own territory, vis-a-vis a very narrowly defined idea of who is a victim of climate change. And so what we're seeing is that some kind of climate claims can be brought to Strasbourg. So it's not zero, but they're being aggregated and they're being depersonalized and decontextualized by being bundled into these big representative NGO-based claims. And that's taking place based on a narrative scarcity. Space on the court's docket is scarce, its resources, its personnel are scarce, but also its legitimacy capital, states' willingness to tolerate interference in their climate-related decision-making is scarce. And as a result, something needs to give and who can be recognized as a victim So in short, the narrative of scarcity has very concrete implications on how the European Court of Human Rights has approached climate change. So there's these very concrete concerns about a flood of cases, about a loss of legitimacy, and about efficiency. This has rather obvious problematic consequences. That's something I've explored in my more recent work in the last couple of years. And the key problem here is that this operates on the assumption that allowing some climate cases from some places and some victims is equivalent to allowing access to protection of human rights to all. That's been accepted in the European context as something that is necessary under conditions of scarcity. So the best we can do is to allow some climate victims. And that, of course, enters a particular protagonist in the narrative around these cases. And that protagonist isn't the people who are impacted by climate change or stand to be impacted in the future. It's the court and the states that are pressuring the court. So to make this more concrete, the fact the European Court of Human Rights has allowed these representative applications from climate organizations doesn't mean that vast and variable impacts on a wide array of rights that are at stake here can be litigated in Strasbourg. So what we've seen is that more procedural, more abstract regulatory cases or claims will succeed, whereas the more granular, equality-based ones won't. We've seen the court, based on these criteria that it's set up, for example, reject cases brought on behalf of youth applicants claiming physical and mental health impacts based on climate change. We've seen the court reject the first indigenous rights argument that was made at this court. We've also seen it reject the first farmers' rights argument that was made based on the right to property. All of these arguments were declared inadmissible based on this very tight understanding of victim status. And there's an underlying sense here that trade-offs need to be made. Trade-offs need to be made between which kinds of claims can be considered in the service of efficiency in the context of scarce resources. And this often gets talked about as something that the court does in service to its subsidiarity or the separation of powers, or trying to avoid an actio popularis strategic litigation case. But I don't think that's the whole narrative. And I think looking at this from the perspective of that neoliberal narrative, scarcity shows us that there's an underlying neoliberal baseline here. So there's an economic narrative in which these applicants need to compete. So they have to be rational economic actors competing for the scarce resources that human rights law has to offer them. And that brings me to the third element of this talk, and it's the question of how we can think beyond this model that the European Court is. So in other words, is there a way to take back epistemic authority, control over how the convention is interpreted, even in the absence of political power? And here's where I think it's particularly useful to focus on narratives instead of, for example, a political realist account of human rights law. Because narratives have some sort of normative underpinning, and they also allow for counter-narratives. So there's a number of questions we can ask ourselves here, some more concrete and some more abstract. So we can ask, for example, whether it's acceptable from the perspective of human rights law to argue that standards should, as is currently being argued before the European Human Rights, to argue that standards should fluctuate along with conditions of scarcity or modern day demands, so that the demands of European human rights law should be lowered when circumstances change, when it becomes harder for states to comply with those obligations. And when we frame the question like this, it becomes clear that human rights law is already capable of dealing with these demands. without changing fundamentally how we interpret that system. So there's some examples here on the slide of how human rights law can already accommodate scarcity by design. So the fact that it includes limitations clauses. The European human rights engagement with climate change has revolved very centrally around Article 8 of the Convention, the right to respect for private and family life. And that right already includes a limitations clause that allows for limitations in service to economic interests. So already baked into this provision is the possibility to account for these conditions. Other things we can talk about as well. We can talk about balancing of rights. We can talk about of progressive realization of economic, social, and cultural rights. And all of that shows that narrowing engagement with climate change already at the point of victim status or jurisdiction, these bottlenecks that have been created before substantive engagement even begins are a lot less self-evident than they're presented as being, because the system already has ways of dealing with these perceived needs of states and these scarcities. And there's more that we could talk about here as well. For example, the idea that the system already features a so-called pilot judgment procedure, which was created to deal with systemic and structural problems that generate high volumes of cases that are similar. So there are already mechanisms in place that allow to deal with high volume issues without necessarily draining the court's scarce resources. We recenter the fact that human rights law accommodates scarcity by design, it becomes even less evident, in other words, why scarcity should limit engagement through the system even further. And it also becomes less evident why it's an issue of judicial legitimacy when cases related to structural, and so when repetitive cases or high volume issues come to the system. And this also allows us to look more specifically and critically at the kind of scarcity, so the nature of the narrative of scarcity that's being advanced here, and the protagonists of that narrative. And that can help, I think, to reframe or to shift the narrative of scarcity in ways that legitimize and don't delegitimize litigation. So one aspect of this is highlighting the differential impacts of scarcity. So the fact that the scarcity narrative that's currently being deployed at the court creates zones of sacrifice. It excludes engagement with non-European victims. It creates hierarchies between not just climate victims and non-victims, but also many others that we can talk about, the human and the non-human, so on. All through these scarcity-informed bottlenecks. And if we look beyond the narrative of climate litigation as an assault on European states and their very restricted resources, or this beleaguered court and its very restricted resources, which is what the scarcity narrative very often looks like right now, and we focus instead on the clear individual and collective, specific and universal impacts of climate change. We understand also the reason why there's disillusionment with the outcome of some of these cases. So there's been quite a bit of research recently that has argued, well, these cases aren't having the impact that we were promised they would, or they're not as transformative as we thought they would be. We need to focus less on climate litigation and more on other areas. Judicial engagement can't or doesn't work is the argument. And I think understanding the power that this narrative of scarcity has had so far in limiting and shaping this litigation can to some extent help to counter that. So it could just as well be that the kind of engagement and follow-up to that engagement that we've seen so far has been too strictly limited by that narrative of scarcity. The second question is one that I think has transformative It's the question, scarcity of what? Human rights adjudicators, and maybe even more than domestic courts, consider the scarcity of their own resources and their own legitimacy capital when they engage with climate change. And as we've seen, there's long histories, including at the European Court of Human Rights, of institutional and political reasons why they do that, right? Legacies of backlash, legacies of reform, state pressure. But in the context of climate change, this is very much the wrong scarcity to form, in my opinion, and also the wrong protagonist to center. What do I mean? So I'm interested in what happens if, instead of scarcity of judicial resources and legitimacy, we center the scarcity of remaining greenhouse gas emissions. I think this could be, or this can be, and has been shown to be, a step towards countering the influence of backlash politics and efforts to limit judicial engagement with climate change. We've seen that, for example, in the German domestic context with the Neubauer judgment, which executed a temporal shift and protagonized the rights of those living in the future, whose freedoms are severely curtailed if ambitious climate action isn't taken today. And we also see the same if we take climate scientific projections seriously. And I have an example of what that can look like. This is just one example. This is a screenshot that I took earlier today. It's a clock created by the Potsdam Institute for Climate Impact Research. And it shows how much CO2 can be released into the atmosphere to limit global warming to 1.5 degrees Celsius, which is the legally agreed target, which we know based on the evaluation of various courts, but most significantly the International Court of Justice made it very clear 1.5 degrees warming is the warming limit that states have agreed on. And if we take that target, they've calculated for us that under current plans and drawing on IPCC reviewed science, currently the carbon budget runs out in about 3 years and 3.5 months. And now there's different ways, of course, to calculate this. There's various methodological assumptions that have to be made. There's various things that can be talked about. But overall, centering the scarcity of remaining emissions instead of judicial resources seems to me to be a starting point for better safeguarding human rights. And that includes conversations also about how 1.5 degrees of warming is, of course, not necessarily safe, and how impacts already happen before 1.5 degrees, and how avoiding disproportionate impacts not only on future generations, but also those of us who will be alive in the term future, means that action has to be taken sooner rather than later. And of course, elements of this are already present in judicial engagement with climate change, including at the European Court. So it recognizes that there is a need for immediate action and binding national regulatory frameworks in order to properly regulate climate change. And this has gotten a lot more concrete if we look outside Europe, if we look, for example, at the way that the Inter-American Court of Human Rights has engaged with climate change. So there we see a lot more considerations of equity and national circumstances. And that court argued that science-based global mitigation requirements, quote, should be considered a minimum starting point rather than the finishing line when determining the mitigation target of the state. What we're seeing currently is limited willingness judicially to challenge the concrete emissions policies of concrete states based on concrete impacts on human rights. So there's a sense, especially on the international level, that fewer victims, fewer violations, and fewer concrete substantive requirements spares the scarce resources of courts. So it protects judicial institutions to engage less concretely with climate change. And where courts do go against this tendency, there's a risk that their findings will be watered down and implementation, which is something we're currently seeing at the European Court of Human Rights. And this is essentially my argument, this reflects that same neoliberal scarcity narrative that ultimately trusts rational actors and the market and the progress that the market brings, especially technological progress, to solve climate change. And for that reason, reframing this narrative from a problem of the markets and allocating scarce resources to an issue of countering hierarchies can be potentially transformative. And on that note, I have reached the end of my reflections, and I very much look forward to hearing yours during the discussion. So thank you very much for your attention.